and welcome to today's episode of Lex Talks, the legal mic voices that inspire. I, Pratibha Singh, the student member of Placement and Higher Education Cell of Thakur Ramnarayan College of Law, would like to take this opportunity to extend my very warm welcome to each and everyone for our today's session of Lex Talks, a platform where experts from industries share their insight and secret to successful career building. Today's episode focuses on child custody under Indian family law under the pretext of child custody under Indian law, statutory provisions, family code practice and judicial extent, a subject that deeply impacts children, families beyond the courtroom. To discuss this today, we are privileged to have with us esteemed expert in this field, Advocate Bhavana Jadhav, ma'am, a distinguished legal professional with remarkable career in this law. Ma'am will share her legal expertise, personal perspective on custody law and evolving judicial trends, helping us to understand better how the law truly serves the best interest of children. So, to begin with, ma'am, could you please tell us how does social stigma around the diverse and single parenting affect child custody in India?
See, it is significantly affected. Admittedly, the Indian society base is on social. Right? We are social animal, and otherwise also Indian society is more family based, and the parents have the root of family. And if one of the family member is not there and divorce going on, the trifle at the house always affect the child, and that itself affect the upbringing and cultural development, emotional development, and per se the entire development of the child, which affects the family and which affects the society and the nation development, I would say.
Yes.
Right?
Yes, ma'am. So, do Indian custody law truly focus on child's best interest?
The base of all the Indian laws for child custodies are based only on the point of paramount interest of the child. All law, Indian Guardianship Act, Indian Adoption and Minority Act, Section 26 of Family Hindu Marriage Act, all these custody laws are based only and only on paramount interest of child. So it is always based on child's welfare. That's it.
It's very insightful to know, ma'am. So, are courts in India moving toward shared parenting and joint custody?
Yes. When there is a trifle between the parties, one party is always scratching the child to be with him, and that is the reason they fight for them. They are using the child as a weapon. But nowadays, our Indian court are moving towards the joint custody, especially in cities. And there was a shared parenting plan also was introduced by our Honorable Judge Palshenkar Sahib, which was to be attached to the petition. Now that point has been referred to the High Court for further consideration. It is on the platform to proceed further. Let's see now when it will be. I am not aware when it will be, but it is in processing.
Hoping for the best, ma'am. So, what do you feel is the biggest problem in family court practice under child custody law?
It's a main issue. The law has been made, but the intention of the party, implementation of the access order is very difficult, because as I said, one party is fighting for the child to be with him, and custodian parent doesn't like to share the child. They are using it as a weapon or a commodities, which is very wrong. The intention of the parties, which is main root cause, and therefore they doesn't allow to have a access by other non-custodian parent, and that is why the access order for implementation, the judge passed the order, but party take out so many excuses not to give access, and that's the main issue.
It's very sad. Okay, so ma'am, to conclude with, I would like to ask you, what's in your opinion, what matters more in custody decision, whether the strict law or the judicial sensitivity toward the child?
Strict law is the skeleton, right? On the basis of the strict law, the judicial sensitivity always matters, and welfare for the child is looking forward in the court. Admittedly, the judge is not a table kursi, right?
Of course.
It's not a table chair. It is the human being who understand the emotion of the parents, who understand the emotion of the child. The child has been interviewed in the court, and the judicial mind by the judges are always applicable in the right directions to pass the necessary access order and the custody order, whichever is favoring the child's benefit. That I have seen in my entire career.
It's very insightful to know this, ma'am. Your legal experience speaks. Okay, so thank you so much, Advocate Bhavana Jadhav, ma'am, for sharing your valuable time and insightful experience with us today. Your thought have really helped us to understand the child custody, not just from legal point of view, but also from the social and human perspective. So, to our audience, we hope this discussion have truly added a clarity and awareness about the child custody under Indian family laws and evolving judicial approach. If you found this conversation interesting and impactful, so please do like, share and subscribe to our channel. Stay tuned for more insightful videos of Lex Talks, the legal mic, voices that inspires, where we continue to bring you important legal decisions and inspiring voices. Until then, bye-bye.